Welcome to Southwest Florida Real Estate Update, hosted by area realtor Jim York and York Real Estate Group of Downing Fry Realty. Our show will bring you the most up-to-date information about the local real estate market, featuring leading experts in the real estate field.
Hello and welcome to the Southwest Florida Real Estate Update. I'm Michael York with the York Real Estate Group, and I'm joined today by our host Jim York and his guest Don Ross, President of Ross Title and Escrow.
Thank you, Michael, for the introduction. Don, and welcome back to the show again. I think we got a great topic here today on the show. What are the most common mistakes that buyers or sellers make when they're purchasing a property? But before we go into that, maybe you could tell our viewers a little bit about yourself.
Oh, okay.
That maybe does not know you.
Somebody who doesn't know me? Name's Don Ross. I grew up in New England. Family's been here since 1972. I'm an attorney in a law firm, title company. I'm one of the members or owners of Downing Fry Realty, Inc. Been doing this over 30 years. And you actually want something people don't know about me? Mm-hmm. 4 kids.
4 kids.
My wife is still married to me, so.
Well, that's good.
I don't know if you want to know more than that.
Where's your office located?
599 9th Street North.
Okay.
Right across from Pastrami Dan's.
Okay.
Not that I'm giving them a plug, but every male in the audience knows where that is.
Yeah, that's right. Don, let's start with the purpose of our show today. Mm-hmm. Is common most mistakes people make when they're buying and selling, and I think we're mostly going to cover the contracts today.
Okay.
So let's maybe start with inspections, because I think a lot of people really don't understand what when they do an inspection, what they're entitled to or not entitled to when they find something wrong with the property.
I find that most people don't understand the process in general, or if they do understand it, they understand it in bits and pieces. They don't understand the time frame. They don't understand the psychology of how to relate to the seller if you're asking for remediation or a credit. They don't understand that there's a limit to what you can ask for in the contract. For example, if the air conditioner isn't working and it's 10 years old, there's a line 251 in the contract that limits the amount the buyer can ask for to the fair market value of that 10-year-old air conditioner if it was in working condition. So they don't quite understand that they're not entitled to a brand new air conditioner or a brand new roof, and they don't quite understand mold. Mold's a big one. Mm-hmm. Mold tends to, in my opinion, strike an emotional chord with people. I'm not quite sure why, but I always compare it to, getting a letter from the IRS. Here I am. I'm a tax lawyer. I have a degree in taxes. I get a letter from the IRS. I still get that, pain in the chest, like, oh my God, what is this? Mold, most of the terms for the different types of mold are Latin terms. So people just know that if a particular type of mold is high, and they don't know if it's the Black Plague or if it's the Penicillium aspergillus, which is plant decaying matter and is everywhere because we're next to the Everglades. They don't realize that the point of the mold test is to find if there's some underlying issue, if there's a leak somewhere, some minor leak, right. If there's something that hasn't been serviced, something minor that you can address now before it becomes a major issue, a year or 2 down the road. When I prepare my clients for the examination of a mold test, I tell them all that this is a good thing. It finds, for the most part, minor issues before they become a big issue, so please don't have a heart attack when you see your mold report. Call me and we'll go over it.
Mm-hmm. And on the inspections, let's just go back to that a little bit. When we do the inspection with an inspection company and they come back with a report, and we find, 20 different things wrong with the place. And I say wrong, there could be some cracking on the patio or in the stucco, or even grout in the showers that need to be replaced. Just define for our viewers what is you can ask for anything, right? And,
Oh,
and
sure.
the buyer's response there. But ask what really is covered in the contract that they're entitled to.
Well, you can ask for anything, and I'm a big fan of asking for everything.
Right.
I mean, the worst that happens is they say no, and then you go back to the drawing board. So being shy is not really a benefit.
Right.
But the contract breaks it down into two categories: items that need to be in working condition and items that are considered cosmetic. You have the appliances, the seawall, the roof, things of that sort that have to be in working condition. And working condition is defined to mean, it's functioning in the way it was designed to function.
Right.
Cosmetic, it's an arbitrary category, and it'll, for example, have under the Naples Board of Realtors contract that we work with most prevalently here in Collier, they'll have missing and torn screens as cosmetic. To me, a missing screen, it's not going to function in the way it was designed to function. It's not going to keep mosquitoes out or the wildlife. Cracked items are generally cosmetic. Limited roof life is a big issue. People get very concerned when they have their roof inspected and the inspector's saying, well, you're going to have to buy a new roof pretty soon. It's not leaking, it's structurally sound.
Right.
And this contract, for the roof to be in working condition, even though it might need to be replaced in a year or so, as long as it's not leaking and it's structurally sound, that's considered working condition.
Right.
So if the buyer or seller don't properly understand that, their expectations are going to be up here when they really should be down here.
Right.
But you still ask for up here.
Exactly.
I mean,
but I just wanted to clarify that.
I mean, I'll tell my clients, well, you're only entitled to this, minimal level. You're only entitled to using the air conditioner again to whatever the fair market value of a 10-year-old air conditioner might be. But let's go ask for a new one, and whatever we get is a huge windfall. And of course, then they don't get so anxious and worked up if they don't get the brand new air conditioner.
That's right.
They're grateful for whatever it is they get.
Right, exactly. Let's take disclosures a little bit, okay? Maybe when you're listing a property, you ask the seller to fill out a seller's disclosure. Maybe you could explain where they could go wrong, either party on that.
Sure. So, I think sellers' disclosures are hugely misunderstood. Most sellers are reluctant to do them. They don't realize that it protects the seller quite a bit. It protects the agent. The agent, as a transactional agent, for the most part, has a duty to disclose certain things. But the disclosure forms that we use in Collier County grew out of a 1985 Florida Supreme Court case that requires sellers to disclose latent material defects. Latent is anything that might be hidden, not readily observable. Material is anything that would affect the fair market value of the item. So the case that they ruled on in 1985, Johnson v. Davis, dealt with a $100,000 house, and the roof leaked like crazy, and they needed a new roof. And it was going to be approximately $20,000. So a $20,000 repair job on a $100,000 structure most definitely affects its fair market value. And the Supreme Court at that point said it's no longer buyer beware. The seller has to tell the buyer if there's something big that's not observable.
That's right.
Now that we've got 30 years of cases since then, expanding on it and interpreting it and so forth. But from that case, we came up with the forms that we use in Collier County that cover things that even aren't material. Why? Well, because once you have a closing, buyers move in, they find out the ice maker isn't working or the dishwasher isn't working, and they start screaming at the seller, they scream at the realtor, they scream at everybody.
Right.
So it avoids a lot of litigation. Probably the biggest case I've seen, and I've been the attorney for Downing Fry for probably 25 years, involved, and this is the example I use when I try to impress upon a seller why it's good for you to do this. It was a house in the estates, and there was a little shed in the backyard, and they discovered termites in the shed. Now, the contract specified the shed was going to be removed anyways. So the seller didn't think they needed to disclose that there were termites in the shed because it was being removed.
Right.
Well, 6 months after the closing, the mother was going in to re-wallpaper one of the bathrooms. She peels the old wallpaper off, and termites come swarming out of the wall.
Right.
The entire house was riddled with termites. The entire house had to be put up on lally columns, or the roof would have caved in. Now, my point is, there is no way for the seller to prove beyond a doubt that the termites that were in that shed were not somehow or another related to the termites in the house.
Right.
And if the seller had simply said, disclosed, that there are termites in the shed, and oh, by the way, we're removing the shed,
Right.
there would have been no lawsuit. Well, there might have been a lawsuit, but there wouldn't have been
Case.
an $80,000 settlement. So it really, even if something's been rectified, if it's termites or mold, something that could reoccur,
Right.
you get the invoice or the report showing whatever it was, whether there was termites or mold, and then the invoice showing that it was rectified, and you give that to the buyer. Say, this is what was done.
Right.
And it creates a certain trust
That's right.
with the buyer, and it helps insulate the seller and the agents.
Well, that's good. How about picking an out-of-state lender? What downfalls is that, maybe?
It's a living nightmare.
Yeah, I know.
It really is.
That's one
I'm
of-
sorry to all the banks out there. I
But
really
it
am.
really is. I mean,
Oh, gosh.
I tell my clients that all the time.
It's the most common thing in the world is, well, we've been using such and such a bank for 30 years. We have all our accounts there. They're from Maryland, say. I'll just choose Maryland arbitrarily. And they do a great job. So they apply for their loan in Maryland. And they're not familiar with our market down here. They're not familiar with the state laws down here. They're asking for things that aren't even legally necessary down here. And within that, plus that industry is in a flux. There's all sorts of new law coming into place August 1st.
Right.
The Fannie Mae, Freddie Mac regs have all changed.
That's
The whole loan process is really, really hard, even if you're great at it.
Yeah.
So if you have anybody less than great, and you need every little bit of an edge you can get just to get the loan done. The communication isn't as good when it's somebody out of state. I mean, if it's somebody in state, I almost always have the cell phone number of the mortgage broker involved. I mean, I can get them on the phone and find out what's going on, but if it's somebody in Maryland, forget it. I mean, it just...
And the appraisal process is sometimes difficult too. 'Cause
Yes. People's understanding of appraisals. You get buyers who think the appraisal is absolutely 100% accurate. That's what the house is worth. And you go to real estate school when you got your license, and we were all taught that an appraisal is an art. It's not a science. They have comparable sales, and then they make adjustments to the subject property based on the differences between the comparable sales and the subject property. So you actually have to look at those comparable sales. How recent are they? Are they the same neighborhood?
Right.
Is there something unusual about it? And I've had probably the worst case. It was a $2 million property, and we had two appraisals, and there was a $400,000 difference between the two appraisals. So all it really does is tell you if you're in the ballpark.
Right.
And if you have somebody who's depending upon that loan and they've waived their financing contingency, I tell them you need to have backup money available if it appraises slightly lower and you have to make up the difference. But they think the appraisal is gospel, and it's an art. It's not a science.
No, it isn't. How about using unlicensed contractors when they're having work done? How can that affect buyers or sellers?
Oh God, there's everybody has a quote-unquote handyman, and knowing what you need a permit for and what you don't, it requires a certain amount of knowledge. There's statutes in place that if you use a handyman, and you don't have to pay them, you don't know the quality of the work they're going to do. The contract calls for licensed people in every aspect of the inspection process. And frankly, if you're dealing with wiring, there's safety issues. I mean, God forbid, you use an unlicensed person and it's not wired properly, and the house burns down. Somebody gets hurt. Now you have a real problem, and it's all to save a few dollars. My wife would shoot me, but we would get quotes on removing the coconuts from the coconut trees in our yard. And I'm always concerned, I want licensed people. God forbid somebody falls and dies and they're not licensed. I want somebody licensed. I want them insured.
Right.
And I make sure it's my house. I don't want to risk it. I don't want the liability. It's worth whatever their expertise. I mean, because we're not electricians or plumbers or carpenters. You know, we rely on their expertise.
Well, Don, we're going to take a little short break, and we'll be right back.
When picking a realtor, don't just pick anyone. Pick someone with experience. Pick someone with a proven track record. Pick a realtor like Jim York from Downing Fry Realty, the #1 brokerage with the most real estate transactions in the area.
My husband and I had very specific ideas about what we wanted in our new home. Jim York was able to help us find the home that was ideal for us.
With over 20 years of real estate experience in Southwest Florida, Jim York has negotiated over $200 million in sales contracts. Selecting the right realtor is a critical decision that can earn you thousands when selling or save you thousands when buying.
Jim also helped us with a mortgage lender and a good real estate attorney. He went that extra mile, and his experience says it all.
Call Jim York for a no-obligation meeting at 239-273-6727 or visit his website, www.naplesyorkrealestate.com.
Welcome back, Don. Let's talk about surveys. How can that affect somebody selling their house, that they have an existing survey and then maybe they did an addition, or explain the non-conforming issues?
Surveys are becoming more and more of an issue. Probably in the last month or so, I've had 5 or 6 transactions. I have one that's closing Monday that was delayed 3-4 weeks and almost fell apart because of a survey issue. The survey law gives precedence to the older monuments of title. When you first develop a piece of real estate, you do a development, the very first monument stuck in the dirt, those prevail over anything that was done afterwards. And surveyors give quotes of a flat fee, so they have a certain financial pressure to get in and get out and get it done. And more I'm finding encroachments with the newer surveys that weren't there on the original surveys. Now, people being people, when you ask the seller to please look for their prior survey, they in many cases don't even know whether they have one or not. So I ask, well, did you have a mortgage? If you had a mortgage, there's most definitely a survey, and we can get it. A lot of the older surveys, is from when they were originally platted, when the development was first started, that concrete marker in the dirt, and you know it's right, and you avoid a whole lot of issues. I was telling you off camera, I've had maybe five in the last month. They were all like very large deals where the seller, well, it might be up in Michigan somewhere, it might be in Massachusetts, so we had to get a new survey, and there's encroachments. The one that's closing Monday, the original development had a front yard setback of 20 feet, a rear yard setback of 20 feet, and the house was 10 feet from the rear and 10 feet from the front. So there's an issue.
That's a big issue.
And it was brought to light by a simple email from somebody at the county with no backup documentation. So it took a good month, dealing with the county, dealing with other surveys, dealing with the underwriter. Can you please look for this and that? And we finally found ordinances that specifically addressed. One was a variance for the backyard, eliminating 6 feet of that setback. And there was another one, ordinance for the front yard, where if you had a 2-car garage, it was only 10 feet rather than the 20 feet. So again, sellers resist the seller's disclosure. They resist looking for their old survey, but it really is a huge benefit to them. The technology has changed in how they measure. The financial pressure on survey companies to get in and get out. The law is almost counterintuitive on this, that the old inexact measurements prevail over the newer, more exact measurements. It's the one area of the law that's just counterintuitive that way. So greatly urge my clients anyways, if you have one, please get it, because that's one less thing that could ruin your transaction.
Okay. Let's just go on to if somebody's selling a property and they have personal property they're selling with the property, furniture, etc. How is the best way to handle that outside the closing?
Well, if it's a cash deal,
It's no problem.
you know it's a cash deal, and the buyer swears up and down it's a cash deal and not going for a loan, then you can include it in the contract.
Right.
And you go to real estate school and they tell you, please do a list.
Right.
But as a practical matter, people aren't going to count every spoon and every fork.
That's right.
So I usually recommend short of the list, which in an ideal world is what you want. But if you're not going to get that, go with the shorter of two lists, either the list of what you're conveying or the list of what you're not conveying.
Right.
If the list of what you're not conveying is the shorter list,
Right.
I'm not conveying, I'm conveying everything except the TV and the kitchen table.
Right.
Then you can say turnkey furnished as of the effective date minus the TV and the kitchen table. Go with the shorter of the two. Now, if you have a mortgage, you've got a major headache. You need to talk to your lender up front. Will having furniture on the contract create a problem? The answer is most definitely yes. And if the lender says that, which I guarantee you they will, the furniture has to be handled outside the closing. The lender doesn't want to see it on the contract. The seller and the buyer are going to have to deal with it just like they would selling a car in the driveway.
Right.
Just like many times on the day of closing, I'm sure you've seen it, where what would you charge for that bookcase? Or,
Right.
And they write a check and they take care of it.
Yep.
And it's not part of what you do or I do. It's not on the closing statement. It's a spontaneous purchase on the day of closing during the walkthrough. So keep it off the contract if it's a loan. Talk to your lender earlier, and that fits in with your financing contingency. If you talk to your lender earlier and tell them what you're doing, they'll look at the amount of money you're trying to borrow and tell you whether or not they even have a program for that, or what they're going to need, or how much time they're going to need.
Right.
And you get many people, they're pushing now to close quicker and quicker, even with a financing contingency, and then the lenders are complaining, to me anyways, quite loudly.
In our contract, by default, you have 45 days for a contingency on a mortgage.
Right.
So what happens if the 45 days goes by? Right. Maybe you could tell our.
Well, that's probably one of the more, that and the inspection clause are probably the most misunderstood portions of this paragraph. I've gotten many realtors, buyers, sellers, say they're in default if they don't waive the financing contingency. This particular contract, the Naples Board of Realtors contract, requires a waiver. And if the buyer doesn't waive the financing contingency, the seller then has the right to terminate the contract and sell it to somebody else.
Okay.
Okay. The buyer doesn't lose his deposit in that situation. But in this particular market, where you're getting multiple offers for a property, the buyer has to essentially choose between risking the deal or risking their deposit. I mean, that's really what it comes down to. And one of my favorite examples, I represented an airplane pilot who used to work for an airline that went bankrupt. And he was buying a $700,000 house, and the seller was pushing him to waive the financing contingency. And he told me, I told him, I said, you got to decide. I mean, I know your lender says this is a lock and you're definitely going to get it and there'll be no problem, but that problems still happen. Which one are you willing to gamble? Losing the house or losing your $70,000?
Yeah.
And because of what he had been through, the bankruptcy and losing his pension, and all his assets were in gold, he told me. He's a very conservative person. He says, I'm not risking my deposit at all, so he refused to waive. Other people have backup money and they can take that chance.
Well, Don, we're going to take another little short break and we'll be right back.
Selecting the right realtor is a critical decision that can earn you thousands when selling.
Jim sold our villa in just 2 days. We got the highest price in the community. He then helped us to negotiate and purchase our new home here in Tiburon. I'd recommend Jim. His expertise made all the difference.
Call Jim York for a no-obligation meeting at 239-273-6727 or visit his website, www.naplesyorkrealestate.com.
Welcome back. Don, we're going to go to a question from Michael right now, okay?
Sure. Don, could you help our sellers in the audience better understand, after they've accepted an offer and more come in, what their options are?
Well, great question, Mike. The seller's options, and this is very common now in this particular market. It's a hot market. The inventory is low. But under, again, the NABOR contract, if the seller refuses to close, the buyer can sue for specific performance damages or terminate the contract and get their deposit back. The seller's options, though, are interesting. I mean, and I've seen this in my day-to-day practice. I've had sellers just say, sorry, I'm not selling it, tough, I'm not doing it, essentially daring the buyer to sue them.
Right.
And most people haven't been through a lawsuit, and if they have, they don't want to do it again. It's not a pleasant thing. It's a very expensive process.
Right.
And unless they're really, really in love with the property, a lot of them will walk away. In fact, that's how I got my house. I went through the exact same thing. My father sold me the house, so when my beloved wife told him that we might be looking for a house, he told his buyer to go take a hike, and I'm selling it to my son, see you later.
Right.
And the person really didn't want to litigate, so he let it go. The other options the seller might have would be, when you look at this contract and you look at all the contingencies, for example, you got the financing contingency, and you have other offers in the wings.
Right.
You're going to terminate after the 45 days if the buyer doesn't waive the financing contingency.
Right.
Or under the inspection clause, if the buyer finds all these things that aren't in working condition,
Right.
And they want a credit from the seller of $20,000, and you have an offer in the wings for more money, you're going to say no.
Right.
So it affects the seller's strategy and how they respond to buyer number one. And the realtor, if they're smart enough to have a realtor involved, will actually lock up the second or third office and make them backup contracts to the first contract, which essentially means this contract is subject to the first contract terminating.
Right.
Okay, so having a realtor would be helpful in that regard. So those are the two main things that the seller can do. Now, I do get a lot of, before the first offer is accepted, other offers are coming in. There might be a phone call, and we're going to send you one in. What do we do there? And I usually recommend that you just tell everyone that there's more than one offer. Make your best offer, and I'll decide by 5 o'clock tomorrow.
Yeah, I've done that too.
Yeah. So that's basically the seller's options in that case. You can live up to the contract, you can tell them to go away and see if they actually sue, or you can be more hardball with your existing contract, with your financing contingency and your inspection.
Well, Don, we covered a lot today. I had some more questions, but we're running out of time here. So I'd like to thank you for coming back on, and I'd like to have you back again, kind of finish up what I didn't get to today. And
always a pleasure. Thank you.
Thank you.